Welcome back. Um, so, how's everybody doing this week? I hope everybody's enjoying their week, enjoying the weather. Hope you have the weekend off. Hope you have something fun planned. If not, I hope you're relaxing. I just got off work, so if my speech tends to speed up as the stream goes on, that's normal. I get really hyper when I'm tired. But I wanted to get on here and do this because I wanted to do it yesterday, but by the time I found out about it, it was time for me to go to work, so I couldn't really do anything about it. Um, Arkansas, Lone Oak County, Arkansas, Aaron Spencer, the candidate for sheriff, has gotten some good news. And but before I get into that, I want to remind you what he was being accused of. And for those of you that aren't familiar with the case, Aaron Spencer is the father of a 13-year-old girl when this began, 14 when it came to a head, and ultimately what he's on trial for. When he found out that a man named Michael Fossler was essaying his 13-year-old daughter. Michael Fossler and Aaron Spencer had a mutual friend, and the mutual friend is the one that told Aaron Spencer about this. Aaron Spencer reported it to the police. The police arrested him. He was put in jail, and Judge Barbara Elmore released him on something like $5,000 or $50,000 bail, with the instructions that he is not to contact Aaron Spencer's daughter. Well, needless to say, he was released and continued his manipulation and deception and essaying of Aaron Spencer's daughter. And he continued to assault this child until finally someone, I believe it was Aaron Spencer, realized one night that his daughter was gone. Apparently her dog was in her bedroom and he was barking, and that wasn't a regular thing, that wasn't normal for the dog. So Aaron Spencer's wife said, "Can you go check on her, make sure she's okay?" He went into her room, and she had a pillow and a sweatshirt over the pillow under the covers to make it look like she was in the bed, but she was gone. Aaron Spencer, knowing that Michael Fossler was out on bail, told his wife to call 911, and he proceeded to go look for them. He was driving down a country road, and a truck passed him going the opposite way, and he saw Michael Fossler in the driver's seat and his daughter in the passenger seat. He turned around to chase them, flashed his lights at him, honked his horn. Michael Fossler wouldn't pull over. So Aaron Spencer rammed him and ran him off the road into a ditch. Aaron Spencer's daughter tried to get out of the passenger side, and Michael Fossler was holding on to her, wouldn't let her go. So Aaron Spencer gets out of his pickup truck. Michael Fossler gets out of his pickup truck. Words are exchanged. Michael Fossler reaches for something. Aaron Spencer unloads his clip on him. Calls 911, says, "You better get here quick." He's charged with second-degree murder. And he's been fighting these charges since then. That was it all began in July of 2024. I think it came to a head on, let me see, in October of 2024, I believe. Not positive. So, needless to say, Michael Fossler dies of his injuries. Aaron Spencer's arrested. He's getting the runaround in this court. There's some corruption going on here in Arkansas also, and so he's really getting the shaft by this Judge Elmore. She just doesn't like him. I think it's because she's the one that I forgot to mention that. The judge overseeing his case for the second-degree murder is the same judge that released Michael Fossler on bail. How about that? How about them apples? If that's not a conflict of interest, I'd like to know what is. Anyway, she just had it in for him, and I think it's because she didn't want to face the repercussions of it's her fault ultimately that all this came to a head like this, because she's the one that released this guy on such a low bail. And she had to have known that it doesn't matter if you give him instructions not to contact this young girl, he's going to. And he did. And it's your fault. So anyway, he's been fighting these charges, and we got word yesterday that the charges have been dropped with prejudice, which I believe means that they cannot be brought up again. He cannot be recharged again. I believe that's what it means. I'm not totally 100% positive, but let's go over the court's ruling, shall we? I'm just so happy for him. And this way he can run for sheriff without any kind of, weight on his shoulders. He can put his whole heart and soul into it, and he can make this county something that people can be proud of. Get rid of some of these corrupt individuals. So, nope, sorry. Where? Why don't I have reader view on here? Jesus Christ. It's always something, right? Okay, let's try something else. I'm sorry. Okay, now I'm ready. Sorry about that. Okay. Order granting defendant's motion to dismiss for due process violation or alternatively for spoliation instruction. After a careful and thorough consideration and review of defendant's motion to reconsider ruling limiting 404A to evidence, to enter order setting aside prior order as to expert witness, and to enter order granting relief for state's destruction of evidence, filed April 20th, 2026, state's response to defendant's motion to reconsider ruling limiting 404 evidence as to expert witness. And geez, this is a long motion name. Okay, anyway, And most importantly, the court the brief in support of defendant's motion to dismiss for due process violation or alternatively for spoliation instruction filed May 21, 2026, state's response to defendant's motion to dismiss for due process violation or alternatively for spoliation instruction filed June 1, 2026, and defendant's reply brief filed June 4th, 2026, and all exhibits and pleadings of record. The court hereby grants defendant's motion to dismiss pursuant to due process clause violation of the 5th and 14th Amendments to the United States Constitution and Article 2, Section 8 of the Arkansas Constitution. This decision is based on the particular, unique, and specific facts and circumstances of this case. Roman numeral 1, background. According to the affidavit for warrant of arrest for Aaron Spencer by Lonoke County Sheriff Detective Rob McCain on October 8, 2024, the affidavit for arrest stated in pertinent part, fast constituting reasonable cause. On October 8, 2024, at approximately 01:13 hours, deputies responded to a call on Highway 236 East in reference to a missing juvenile. Deputies were advised that the missing juvenile had been raped and essayed by a Michael Fossler in July of 2024, and that he was known to drive a white Ford F-150. Lonoke County Dispatch requested that Cabot Police Department send officers to an address within their city to try to locate the missing juvenile at Michael Fossler's residence. They keep putting Foster. It's not Foster, it's Fossler. Prior to receiving information from Cabot, dispatch received a second call from the father of the juvenile, identified as Aaron Spencer, stating that he had located the man who kidnapped my daughter, end quote, Michael Fossler, and his daughter, but that the male was dead on the side of the road and that he had no choice. Deputies arrived at the address inside the rural area of Lonoke County and located both Aaron Spencer and Michael Fossler. Deputies immediately began life-saving measures on Michael Fossler, but he had succumbed to his injuries. Deputies took Aaron Spencer into custody and secured the female juvenile away from the scene. Deputies cleared and stored the weapon, a Glock 19 Gen 4, that was found to have been on the person of Aaron Spencer and had blood on the outside of the weapon. Detective R. McCain, was the first detective on the scene. Upon arriving, I observed a white Ford F-350 sitting north at the scene, angled in the northbound side of Highway 13, with a white Ford F-150 sitting next to a driveway. The Ford F-150 appeared to have been forced off the roadway due to skid marks located on both the asphalt surface of the highway and through the ditch line. Michael Fossler was lying on his back in a ditch on the east side of Highway 13. Michael Fossler had visible puncture wounds believed to be caused by a firearm projectile on his chest, abdomen, and both his left and right arms. Upon inspection of the white Ford F-150, damage was located on the rear of the vehicle, normally seen after impact with another object. A search of the area was performed. During the search of the area, several spent 9mm casings were found on the roadway, driveway, and ditch surrounding the Ford F-150. Once clearing the scene, myself and Detective Ann Rice interviewed Aaron Spencer at the Lonoke County Sheriff's Office after being advised of his rights, to which he acknowledged understanding, in reference to events that had occurred. Aaron Spencer stated that he had been woke up by his dog barking, which was uncommon, and went to check on his daughter's bedroom on his daughter's bedroom due to the events that had occurred earlier in the year. Aaron Spencer further explained that he looked closer at what he thought was his daughter in bed. He realized that it was actually a stuffed animal with his daughter's hoodie on it. Aaron Spencer stated he became scared of what had happened to his daughter and had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fossler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, He observed the white Ford F-150 belonging to Michael Fossler turn off of Highway 31 onto Highway 236 East, heading toward his residence. Aaron Spencer then stated that he was in fear for his daughter's life and continued to pursue Michael Fossler east on Highway 236. Now, the reason why he was in fear for his daughter's life is because Michael Fossler is facing life in prison for these charges that he's going to trial for. And we all know how well pedos are accepted into prisons, right? I mean, nobody likes them. They're scum. So the only way he could get out of going to prison is if there's no witnesses. And the only witness in this case was the victim, Aaron Spencer's 14-year-old daughter. But if she's not alive to testify, he walks free. So he comes over in the middle of the night and kidnaps her. What do you think he's going to do with her after he's done graping her? He's going to probably unalive her. I mean, let's be truthful. Let's be honest. Let's put it all out there, right? I mean, so that's why Aaron Spencer was in fear for his daughter's life. Not to mention, she's being assaulted and, raped at the hands of this 63-year-old, I think he was, 63 or 67-year-old male. Disgusting. Aaron Spencer explained that when they arrived at the intersection of Highway 236 East and Highway 13 North, he hit Michael Fossler's vehicle in the rear, causing it to slide off the roadway. Aaron Spencer then stated he exited his vehicle with his firearm in hand and ordered Michael Fossler out of his vehicle and to lay down in the ditch. Aaron Spencer stated he observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fossler had grabbed her and stopped her from getting out. That takes some balls, dude. Aaron Spencer then stated that Michael Fossler then lunged towards him, saying, "Fuck you." Aaron Spencer stated that he then opened fire on Michael Fossler, emptying his weapon before jumping on top of him and pistol whipping him. Aaron Spencer then stated he got his daughter out of the vehicle and returned to his truck, where he reloaded his weapon and called 911. He's a hero. He's not a murderer. Roman numeral 2, judicial notice. The court takes judicial notice that the victim in this case, Michael Fossler, was charged by information on September 4th, 2024 in the Lonoke County Circuit Court in case number 43CR24239 with 43 sexual-related offenses, 2 of which were Class Y felonies, with defendant's minor daughter as an alleged victim. The alleged offense dates were between June 1, 2024 through July 5, 2024 in Lonoke County. There is a fake copy of an unfiled form document under the heading. In the Circuit Court of Lonoke County, Arkansas, with pending charges box checked and styled. Pretrial order in the case of State of Arkansas versus Michael Fossler, in handwriting with the date of July 12, 2024, filled in, showing a bond amount of $50,000 with a form box checked stating, quote, "The defendant shall have no contact, either directly or indirectly, in person, by telephone, mail, social media, or any other means, with any minor apparent or his or her immediate family or friends." The court also takes judicial notice that Michael Fossler did not appear before a Lonoke County District Court judge for a first appearance Rule 8.1 hearing. Although the document referenced above was in the Lonoke County Circuit Court, it was signed by a Lonoke County District Court judge, was unfiled, and wasn't discovered by defendant's discovery request until late 2025. Furthermore, Michael Fossler's first appearance in Lonoke County Circuit Court was on September 6, 2024, when he appeared with counsel, entered a waiver of arraignment with a pretrial date set for December 3rd, 2024, and a jury trial set for 12/4 through 12/6. Under our legal system, Michael Fossler was presumed to be innocent. Number 3, applicable case law. The recent Arkansas Supreme Court case of State v. Clark's 2024 Arkansas 158 and the U.S. Supreme Court cases cited within the opinion control the issue of defendants' alleged due process violation by the state for the destruction or loss of material potentially exculpatory evidence. The relevant U.S. Supreme Court cases mentioned in this opinion include Brady v. Maryland, California v. Trombetta, Arizona v. Youngblood, and Illinois v. Fisher. The Clarks case reversed the trial court's dismissal of 5 felony counts on a denial of due process claim for law enforcement's failure to preserve body camera evidence, partially because the Arkansas Supreme Court held that it is the defendant's burden of proof to show a due process violation on those grounds. The Brady case recognized that the due process clause is triggered when the prosecution has suppressed material exculpatory evidence, and that the defendant has the burden of proving a Brady violation. The opinion defined exculpatory evidence as, quote, evidence that may tend to exculpate or reduce the defendant's culpability, end quote. After discussing the U.S. Supreme Court and other Arkansas cases, the Clarks case took the opportunity to clarify the standard for courts to employ when the state loses or destroys evidence. It said that the state violates the due process clause when it destroys or loses material evidence. 1, whose exculpatory value is apparent before destruction, and 2, the defendant cannot obtain comparable evidence by any other reasonable means. And the evidence that they're talking about that was lost is an SD card out of Fosler's dash cam. The state also violates the due process clause when it destroys or loses evidence. 1, that was potentially useful in the defendant's case, and 2, the government acted in bad faith in the destruction of the evidence. Again, a defendant must prove that the state violated either or both tests to obtain a relief for violation of the due process clause for loss or destruction of evidence. Here, defendant must prove both prongs of either or both tests. The court will next address the arguably harder prong to satisfy, bad faith. Just 1 second. I always get cotton mouth when I do these. A, bad faith prong. The Lonoke County Sheriff's Office has a detailed policy 16-1 effective 11/1/14 that sets out policies and procedures for the handling and processing of evidence. At issue here is the dash camera found by Lonoke County Sheriff's Office deputies and a detective on duty in the alleged victim, Michael Fosler's truck at the scene of the events, giving rise to this case in the early morning hours of October 8, 2024. The dash camera, mounted on the front windshield, just to the right of the rearview mirror of the decedent's truck, had dual cameras, allowing it to record events in front of the truck, inside the truck, and potentially behind the truck. My eyelashes keep hitting my glasses. I hate that. So I have to put them down here, and then look at that. That looks stupid. But if I put them up where they're supposed to be, my eyelashes drag on the lenses. It's annoying. Number 1, LCSO Detective Robbie McCain at the scene removed the dash camera from the windshield. 1, without its original position on the windshield's truck being recorded, photographed, or sketched as part of the crime scene, nor was the dash camera itself photographed or recorded. A, Policy 16-1 procedure. Collection of evidence. Quote, after locating an item considered pertinent to the case under investigation, it should not be disturbed until it has been photographed, measurements taken, its position recorded on the crime scene sketch, and entered into the officer's notebook. Detective McCain's actions that morning violated that procedure. According to an inspection by Jason Stacey, a retired Hot Springs police chief who testified under oath at a December 2025... Just 1 second. Okay, sorry about that. Something keeps beeping. I don't know what it is. So hopefully I fixed it. I think it was my alarm. Not positive, but I guess we'll know soon enough. Okay. According to an inspection by Jason Stacey, a retired Hot Springs police chief who testified under oath at a December 2025 pretrial hearing, the dash camera mount was broken when it was removed from the windshield of the decedent's truck, and the dash camera's internal settings were not preserved, and its internal battery was allowed to drain, resulting to a default setting of August 1, 2024, which probably rendered the dash camera useless after that time. 2, as for the SD memory card found within the dash camera, they're terrible writing. Look at that, within the dash camera, Detective McCain stated in his affidavit of December 2, 2025, that he noticed that the dash camera had a micro SD card inserted in it. Detective McCain removed the micro SD card out of the dash camera and placed it into an adapter for a regular size SD card into a card reader and opened it on his computer. He said he viewed 3 videos of 15 minutes and a 4th video less than 15 minutes. He further stated that he placed the micro SD card back into the dash camera and placed it back into the original manila envelope. That is controverted by expert witness for purpose of the pretrial hearing of December 17th through the 18th, 2025, Brandon Purchase. According to Jason Stacey's affidavit, Detective McCain and Lieutenant Giacomo Portali, CID head at LCSO, stated the LCSO's standard practice is not to manipulate electronic devices or check for SD cards before sending the devices to the Attorney General's Digital Forensics Unit. They said the reason for this policy is, quote, not to manipulate, end quote, the electronic devices at all, because doing so takes a chance of wiping data and everything else. Furthermore, Stacey said Detective McCain was trained not to remove SD cards because of the risk of wiping data, and that he, Detective McCain, like other LCSO officers, generally does not check whether a device contains expanded memory. Finally, according to Stacey's affidavit, Detective McCain said they disliked manipulating any other equipment before it was sent to the AG's office. B, after removing the SD card from the dash camera, Detective McCain did not photograph the SD card, record its data storage size, or mark it as a separate item of evidence, contrary to LCSO 16-1. Actions taken by Detective McCain in this case appear to violate Section 2, identification of evidence. Quote, all recovered evidence must be immediately and properly marked or labeled in order to assure its proper identification at some later date, end quote. Further, each piece of evidence must be marked when it is removed from the original position. Evidence will be marked by use of deputies' initials and evidence/case number when practical. The date of recovery, case number, and similar identification shall be fixed to the exhibit whenever possible. Additionally, Section 3, Preservation of Evidence, states the integrity of evidence may be further protected by selecting a container that will guard against damage or contamination. A, place each item in its own container or paper wrapping. B, after the article has been marked, place in a container and sealed, a label or tag will be affixed. C, deputies must also log all property in the property section in their report in SOMS so that the evidence custodian can properly maintain the chain of custody. Next is Section 4, chain of possession. The correct methods used in collecting, identifying, and packaging evidence may be nullified if an officer cannot account for all persons who have handled, examined, or stored the evidence. Each deputy is responsible for maintaining the chain of possession and protecting the integrity of his or her evidence. Section B, if the evidence leaves the deputy's possession, he/she should 1, record his or her notes to whom it was given. 2, the time and date. 3, the reason for being given to another person. 4, when and by whom it was returned. The court finds that Detective McCain's actions did not comply and violated LCSO Policy 16-1 in the ways enumerated. Another area of concern is the information contained within the Tim Griffin Attorney General request for forensic examination form. That form shows an item of evidence, E1, a black/silver 1080p camera, was submitted by Sergeant Carla Lucas on 11/14/24 and received by S.A. Calmer. Within the large box on the upper right hand of this form is the box, quote, on-site preview, end quote. Checked unknown, presumably for unknown. This item of evidence, presumably the dash camera, was returned to the Lonoke County Sheriff's Office on 10/16/2025, 11 months later. In the LCSO evidence detail form, it was listed that this evidence was sent to the AG office on 10/14/2024 and checked back in from the AG's office on 10/16/2025. This form indicates the acquired location was Michael Fossler's windshield, and this item of evidence was acquired on 10/8/2024 at 0413, acquired by Robbie L. McCain and given evidence number E85. So even then, it took him 6 days to get it to the AG's office, right? Or whoever. Oh, it was checked. Yeah. So even then, I mean, from the 8th to the 14th, where was it? Between those 2 dates are a series of emails between the prosecutor and defense counsel on July 3rd, 2025. The first email is a disclosure from the prosecutor to defense counsel to let her know about a dash cam that was apparently in the decedent's truck that was taken into evidence by LCSO after the incident, and that Detective McCain took the micro SD card out and reviewed the video files on it, but all the files showed to be after the incident and just showed blue lights in the background and no other exculpatory/inculpatory evidence. That email also indicated that the dash cam unit, along with the SD card, were sent to the AG's office for Amber Calmer to do a forensic exam on it, but it has come up missing. That email also referenced Detective McCain unplugging the dash cam. A follow-up email stated there was no internal storage within the dash cam, and that is the crux of this missing, lost, or destroyed evidence not preserved by the state. The court is unable to discern when the Attorney General's office informed LCSO that the memory card was missing. There is one last discrepancy before moving on to the December 17th, 18th, 2025 pretrial hearing transcript. This LCSO evidence detail form also indicated this dash camera item of evidence was sent to the AG office on 10/14/2024, whereas the AG form listed above shows that office received this dash camera on 11/14/2024, as stated in paragraph above. The state asserts this is a clerical error. Detective McCain's testimony at December 2025 pretrial hearing points. 1. Detective McCain did not photograph the dash camera position or location and did not document its existence in the incident report. Number 2. Detective McCain admitted that the camera was not logged into evidence but was instead stored in his personal office rather than the evidence room. An oversight it wasn't logged into the system and it got missed. How does that happen? This is your job. This is something you do every day, right? I mean, how does that happen? And yet we hear about it all the time. Number 3, the dash camera was not logged into evidence until over a year after it was collected. 10/8/2024 to 10/16/2025, a violation of preservation of evidence procedure. Number 4, Detective McCain removed the memory card from the dash camera before logging it into evidence and viewed the contents on the computer in his personal office, not in the evidence lab. Number 5, Detective McCain said this was the only dash camera LCSO has ever seized during an investigation. So you don't know how to, but you knew how to take the SD card out. So that's not an excuse. And if you've never seized a dash cam during an investigation before, then why did you take this one off the dash? Why didn't you just leave it and let somebody who was experienced in seizing dash cams, let them do it? Just take the whole truck. You're going to anyway. Number 6, after viewing the contents of the memory card, Detective McCain testified he placed the card back inside the camera, placed the camera in an untaped envelope, and put the envelope in his office cabinet rather than logging it into evidence. Why? Note, pretrial expert witness Brandon Purchase noted the SD memory card snapped securely within the dash camera. Number 7, Sergeant Carla Lucas took the dash camera from LCSO to the AG's office on 11/14/24 for examination. Number 8, the AG's office did not receive the SD memory card containing the data from the dash camera. So if he put it back into the camera, and the camera was given to the AG's office for examination, why wasn't the SD card in the camera? Number 9, none of Detective McCain's actions regarding the dash camera was documented in any database or log, a violation of LCSO written procedures. Number 10, Detective McCain's failure to place the dash camera into evidence resulted in the camera not being logged into the system of evidence until 10/16/2025. There was no mention of the existence of a dash camera in any discovery or law enforcement document until it was returned from the AG's office on 10/16/2025, when Detective McCain listed the dash camera into evidence as item E85. The SD memory card and dash camera should have been listed as 2 entries if separated. Number 12, LCSO, which is Lonoke County Sheriff's Office, typically sends electronics, digital evidence, computers, and phones to the AG's office for examination. In this case, with the exception of the dash camera, LCSO sent all the other items, including memory cards, phones, computers, tablets, etc., to the AG's office without first attempting to view them in office. But yet he had to check the memory card on the dash cam. That's pretty odd. 13. Detective McCain did not document accessing the SD card or what he said he saw when he did so. As an aside, there is a reasonable possibility that he didn't see what he said he saw based on the sworn testimony of expert witness Brandon Purchase and affidavit of Jason Stacey that powering off the camera does not delete anything from the SD card. However, the court was not present at the PT hearing, so no credibility findings can be made. Other testimony during December 2025 pretrial hearing. 1. LCSO Lieutenant Portali stated that Detective McCain's 1. Failure to document the removal of the dash camera from the decedent's truck, and 2. Failure to document pulling the SD card out, 3. Failure to document what he purportedly saw, and 4. Failure to document its loss, all violated policy. Number 2, there was other testimony at this pretrial hearing that indicated that the decedent's truck's accessories still powered up and running the video camera, and that Detective McCain unplugged the dash camera. It powered down, and that a splash screen went off, which was disputed by Brandon Purchase, but the court will not make a credibility finding on that issue. Why not? Number 3, there was other testimony at this same pretrial hearing that indicated that Attorney General Special Agent Amber Calmer found no SD memory card when she opened the package containing the dash camera, and that there were 6 SD memory cards found in the decedent's house and 6 SD memory cards found in the decedent's truck in separate searches by LCSO. In view of these cumulative deviations from LCSO policy and procedures and outright violations of these procedures and best practices and intentional actions of law enforcement in not preserving the critical SD memory card, it has been lost or destroyed. This establishes a pattern of policy and procedure violations and gives the appearance of a cover-up. The state argues that these series of violations were mistakes, errors, negligence, and unintentional, not amounting to bad faith. The state further argues that the definition of quote-unquote bad faith is limited to the definition set forth in the Starks case. That case also said, citing Trombetta, when law enforcement followed their standard operating procedures typically shows a lack of bad faith. That also says... Conversely, it can be logically argued that failing to follow standard operating procedures is evidence of bad faith when combined with other factors, as here. Defendant has cited cases from other jurisdictions that define quote-unquote bad faith regarding loss or destruction of evidence as evidencing bad faith. 1. Efforts to conceal the existence of exculpatory information, its contents, or its destruction. Failure to adhere to rules and professional obligations. 3. Deliberately omitting mention of evidence or omitting information from reports. And 4. Failure to submit an item of evidence, denying its existence, failing to timely alert others to destruction of evidence, or misleading as to the circumstances. These definitions, while not precedent, are influential, helpful, and persuasive. The court therefore finds that the defendant has proven bad faith on the part of the state in these particular and unique facts and circumstances outlined above. Therefore, the bad faith prong has been satisfied. B. The dash camera and SD memory card as potentially useful evidence in defendant's case prong. Transcript evidence at December 2025 pretrial hearing. 1. LCSO officers McCraney, Lucas, and McCain acknowledged the evidentiary significance of the dash cam. 2. Both Deputy McCraney and Detective Lucas answered yes when asked if they immediately recognized the dash camera as an item of evidentiary value. Just 1 second. Defendant has advocated that it is logical and legitimate that the dash camera would provide exculpatory evidence, assuming the dash camera was working and was operational as it was plugged in at the time it was removed. Okay, defendant asserts the following Defendant asserts the working dash camera would have provided 1. The decedent's custody of defendant's daughter. 2. The decedent's directives to defendant's daughter in the truck. 3. Defendant's attempt to get the decedent to stop the truck and the decedent's refusal to do so. 4. The decedent's active fleeing from defendant with defendant's daughter in the decedent's control. 5. Defendant's successful effort to safely maneuver the decedent's truck into a driveway. 6. The decedent's aggressive exit, including the language he used when he exited his vehicle. The court further notes that the state, in its response, agrees with defendant that the dash cam and SD card possessed quote-unquote potential exculpatory value and would have been potentially useful for both defendant and the state. Based on the evidence and defendant's argument, the court finds that defendant has proven this prong, thus satisfying both prongs of the second test under the Clark's opinion. The state also violates the due process clause when it destroys or loses evidence. 1. That is potentially useful in the defendant's case, and 2. When the government acted in bad faith in the destruction of the evidence. The court will also address the other test requiring defendant to prove 1. That the exculpatory value is apparent, and 2. The defendant cannot obtain a comparable evidence by any other reasonable means. A. Exculpatory value of evidence is apparent before destruction prong. Defendant addresses this prong as his first point in the brief of May 21, 2026. This issue is intertwined with the actions of bad faith discussed in prong 1 of the first test herein. The second prong of the first test, evidence that was potentially useful in the defendant's case, is also related to this prong of exculpatory value. Defendant's brief thoroughly and extensively addresses this prong with facts and arguments, which the court finds persuasive. The court finds that the defendant has met his burden of proof as to this prong, the exculpatory value of the dash camera and its internal memory card before it was lost or destroyed. B. Defendant's inability to obtain comparable evidence by reasonable means prong. As defendant points out in his brief, video and audio of the dash camera, assuming it was functional and recording, would have demonstrated what defendant would have witnessed and experienced in real time. Video evidence is objective and not altered by human perception or bias or self-interest. Meaning, video doesn't lie. Defendant correctly asserts he has a Fifth Amendment right not to testify and cannot be compelled to testify, so his own testimony cannot satisfy the comparable evidence factor. As argued by the state in its response, the only other eyewitness to the events in this case was the defendant's daughter. However, her testimony may be colored by the stress and trauma of the events of that late night/early morning. Dash camera footage would be the only objective evidence of that early morning encounter. Plus, you don't really want your daughter to go through that. The defendant cites in his brief 3 federal district court cases from Utah, Idaho, and Michigan. In all 3 cases, video evidence was available, but unfortunately, no video evidence is available in this case. The U.S. v. Webb case of May 24, 2023 involved video evidence of a traffic stop that showed objective evidence that contradicted the officer's testimony during a field sobriety test that nullified the probable cause to charge the defendant with the DUI. In Gasser v. Village of Pleasant Prairie, the video defeated a police custodial claim of excessive force. Based on the video, no reasonable jury could believe Gasser's version of the events. Finally, in Payne and Colvin, a 2025 federal district court case, the trial court stated, quote, "When subjective evidence conflicts with video evidence, we must view the facts in light of the video evidence." These courts reinforce common sense that competent video evidence is objective and neutral and not subject to human biases or deficiencies in perception. These federal trial court cases are helpful and persuasive, even though they are not precedent for a point. Even if they are not precedent for state court, but their holdings do assist defendant in meeting his burden of proof on this point. Therefore, the court finds that the defendant has met this prong as to the first test. Roman numeral 4, remedy. Defendant Aaron Spencer filed notice of intent to raise justification as a defense on December 3rd, 2024. Specifically, defendant has raised the defenses afforded to him in Arkansas Code, and then it gives the numbers. Having found a due process clause violation under both tests of State v. Clarks, the court finds that the loss or destruction of the internal SD memory card of the dash camera has adversely impaired defendant's ability to defend himself pursuant to these defenses, and thus his right to a fair trial. The next issue is that of a remedy in this case. The last paragraph of the Clark's opinion noted that none of the cited cases mention the appropriate remedy if a due process violation is found. That there may be occasions when conduct by law enforcement is so egregious that it warrants dismissal, but those should be outliers. The state argues this is an extreme remedy. Therefore, the court acknowledges that dismissal is an extraordinary and extreme remedy. However, based on the totality of the circumstances and the unique, specific, and particular facts and circumstances of this case, the court finds that conduct by law enforcement was so egregious that dismissal of this case is warranted. Therefore, this case is dismissed. It is so ordered. Ralph Wilson, Jr. Wow. That is so I just can't even, I can't even imagine what he's feeling right now. Wow. I know that we were supposed to go over the Karen Reed's new civil filing today. She filed a new civil suit against the Canton Police Department, City of Canton, and the MSP. And we are going to go over that because I'm telling you what, the shit that came out in Proctor's phone extraction, and this is just part of it, because there were thousands of text messages, videos, pictures, emails. This is just like a handful of them. They are I mean, I knew that they had to be bad just because, he withdrew his appeal to being fired, and his union rep lawyer, dropped him as a client. And I mean, so you just knew that they were going to be bad, but I don't think anyway, did not. I don't know what I was expecting. I just have a hard time believing that somebody can live like this and feel this way about particular people, and nobody around him knows. His wife doesn't know that he feels this way. I mean, he is such a misogynistic prick. And it all comes out, and he shows his true colors. I mean, they say you can judge a person, and you can tell who a person really is by what they do when they think no one's watching. And I just can't imagine these people spending all this time and money trying to convict Turtle Boy in Kearney of all these intimidation crimes, trying to put him in prison for 90 years he's facing. And yet his phone extraction, all it shows is some sexual, exploits or whatever, You don't see any racist remarks from him. You don't see any, I want to grape my girlfriend from him. You don't see any of that stuff. But you sure see a lot of it in Michael Proctor's extraction. So who's the one that should be put behind bars? Right? Who's the real scumbag? Because they have Aiden Kearney's extraction. He hasn't even gotten to see it yet, but everybody else has, and you don't see any of this kind of stuff, language or anything, in his extraction. So the money and time that they are putting forth in trying to get him behind bars is mind-blowing to me. And yet they want to just let Michael Proctor walk off into the sunset. Bullshit. I say no. He doesn't deserve to. He needs to face what he's created. I mean, he created this farce, I don't even know what to call it, but you might as well be proud of it, because it's probably the last thing you'll ever create as a law enforcement officer. And I just can't help but wonder how many cases this is going to affect. I mean, they talk about, God, my hair looks terrible. It's all fuzzy. He talks about, planting evidence, and I don't know. It's just mind-blowing to me that I don't know. And I find it hard to believe that his family, his wife, didn't know that he was this way. But I guess we'll find out, because if she doesn't leave him now, then she knew. She knew. Because I'll tell you what, if I found this stuff out about my husband, I wouldn't even pack my shit. I'd just have somebody else come get it after I left. I mean, he has to move. He has to move out of state. He possibly has to move out of country. I mean, because his name now is synonymous with racism, misogyny, corruption. How can you stay there? I would never order, if I did stay there, I would never order food from a restaurant, because they're probably spitting in it. Don't do that to your kids. Don't stay there. Get out of there. If she wants to stay there with the kids, fine, but you need to leave. Don't subject them to the shit that you brought down on your family. Be a man. and leave. Move. Go somewhere where they like your type, which I don't know where that is. Probably some isolated piece of land in Alaska, maybe, um, where you don't have to see all these um, different types of people that just get under your skin so bad that you just can't stand, to the point where you wish them harm. I couldn't imagine living my life that way. Just couldn't imagine. And I don't think he's 100% white, right? He looks Italian or something. So who is he to judge what is white? And you know what I mean? He's not. Nobody is 100% white. I don't care what you say. We're all Heinz 57. You know, I mean, it is so beyond anything. I don't know. I have no words for it. So, but I know we were supposed to go over that, and I'm just going to ask you that you forgive me. We're going to go over it in about 2 hours. I just need to take my dogs for a quick walk before they drive me crazy and keep interrupting the stream. That's the main thing. So, if you just let me do that, I will be right back, and we will go over Karen Read's latest civil case. Again, Aaron Spencer, congratulations. May peace be with you and your family now so that you can begin to heal. We pray for your daughter. We pray for you. Good luck in the election. They will be lucky to have you as sheriff. And it couldn't happen to somebody better. You're a hero. That's all there is to it. You're a hero, and I would rather my husband do what you did than not. And I wish every father would step up and do that for their own child, but I can't say that everybody would. I think that they would be too afraid of the consequences after the act, like being charged with second-degree murder. But that didn't even cross your mind, and for that I commend you and I praise you, and I hope that now you can find peace and try to move on from this ordeal. And I hope your daughter can soon find peace and move on from this ordeal. I know that it will be with her forever, and it's just time for her to heal, and she deserves peace. So congratulations and good luck on your election. Okay, so I'll be back in about an hour and a half, and we'll go over the Karen Read stuff. Okay? Don't forget to like and subscribe. And yeah, ciao for now.